Generative artificial intelligence, administrative acts, and judicial review in China, with lessons for Australia. Why AI administration matters now. In recent years, generative artificial intelligence tools like ChatGPT and large language models has moved rapidly from novelty to infrastructure. In China, this shift is especially visible in public administration. AI systems now assist with licensing, enforcement, regulatory drafting, and even administrative penalties. Today's episode is based on a 2025 Chinese legal scholarship article by Sun Shangyuan titled Qualification and Judicial Review of Generative Artificial Intelligence to Make Administrative Acts.
生成式人工智能做出行政行为的资格认定与司法审查。
At its core, the article asks three deceptively simple questions. 1. Can generative AI be treated as an administrative actor? 2. Do AI-generated outputs constitute administrative acts? 行政, 行为. How should courts review such decisions when citizens challenge them? These questions are not uniquely Chinese. Australia, too, is experimenting with automated decision-making, from visa processing to welfare compliance, raising parallel issues of accountability, transparency, and judicial review. Before we go further, let me introduce two key terms that will recur throughout this episode. Administrative Act, 行政, 行为, a legally binding act by a government authority that affects rights or obligations. Automated decision-making, 自动化决策, decisions made primarily or entirely by algorithmic systems. Legal and policy background. Why generative AI challenges administrative law. Chinese administrative law, like Australian administrative law, was built on a simple assumption. Decisions are made by humans. Traditional theory requires a human decision maker, a discernible intention, responsibility, and accountability. But generative AI disrupts this model. AI systems today generate penalty notices, draft licensing decisions, answer policy queries, pre-screen applications. This creates tension with Article 24 of China's Personal Information Protection Law,
个人信息保护法第24条
which regulates automated decision-making and guarantees transparency, fairness, the right to explanation, the right to refuse purely automated decisions that significantly affect rights. Here we encounter a critical legal fork. Is AI merely a tool, or is it becoming something closer to a decision maker? Australia has faced a similar dilemma. The infamous robo-debt scheme relied on automated calculations to issue debt notices. Courts later found that the absence of lawful human judgment rendered those decisions invalid. China's legal scholars are asking the same foundational question, but within a civil law and governance-oriented framework. Section 2, Core Legal Analysis. Can AI qualify as an administrative subject? The article's central concept is qualification recognition. 资格认定. Chinese law traditionally recognizes only natural persons, 自然人, legal persons, 法人, unincorporated organizations, 非法人, 组织. AI fits none of these. Sun Shengyuan rejects the idea that AI currently possesses legal intention, 意思表示, capacity to bear responsibility, 责任能力. Therefore, the article's key conclusion is clear. Generative AI does not possess independent administrative subjectivity.
生成式人工智能不具备独立行政主体资格。
Instead, the law must distinguish how AI is used. 3 models of AI administration. The article identifies 3 modes. 1. Independent decision-making. 独立决策模式. AI completes the entire process. Legally risky. Responsibility still attributed to the agency. 2. Assisted decision-making. 辅助决策模式. AI proposes, humans decide. Preferred model. 3. Recommendation generation. 建议生成模式. No legal effect. Lowest risk. This mirrors Australian administrative law's insistence that decision makers must actually decide, not merely rubber stamp algorithms. Section 3. Judicial review and comparison with Australia. Who gets sued when AI decides? A practical question arises. If an AI-generated administrative decision is challenged, who is the defendant? The answer is unequivocal. The administrative agency. 行政机关, not the AI, not the developer. This aligns closely with Australian law, where automated systems are treated as decision support tools, not legal actors. Algorithmic review, legality versus reasonableness. Chinese courts, the article argues, should adopt a layered approach. Legality review, 合法性审查. Limited reasonableness review, 合理性审查. This parallels Australia's reluctance to engage in merits review while still policing procedural fairness, jurisdictional error. Unreasonableness, the Wensbury style, refers to a strict legal test used in judicial review, primarily in the UK and other Commonwealth administrative law systems, to determine if a public authority's decision was so unreasonable that a court can intervene. A notable innovation proposed is layered explanation obligations. 分证说明义务. Tailored to the public, the affected individual, the court. This is arguably more sophisticated than current Australian transparency norms. Section 4. AI administration and the return of legalism. Pros and cons of a legalist turn. Here we arrive at a deeper philosophical issue. China's approach risks drifting toward a legalist Fajia mentality. Pros: predictability, efficiency, uniform enforcement, reduced discretion and corruption. Cons: over-mechanization of justice, loss of contextual mercy, qingli, reinforcement of rule by code rather than rule of law, citizens reduced to data points. Legalism historically prized control over consent. AI administration, if unchecked, may revive this logic in digital form. Australia, by contrast, risks the opposite extreme: algorithmic opacity without strong central coordination. The lesson is not imitation, but mutual caution. Conclusion: what this means going forward. This article ultimately delivers a balanced message. AI is not an administrative subject. AI decisions remain human responsibility. Judicial review must evolve, but not abdicate. For both China and Australia, the challenge is the same. How do we use AI to enhance governance without surrendering legality, accountability, and human judgment? I'll leave you with a closing line in both languages. 法律之桥，连接世界. The bridge of law connects our worlds. Stay connected.